Hello everyone. Welcome back to my channel Study with Neha Mawa. I welcome you all and I'm glad you are here, those who are watching my video and are gaining something knowledge from this video. So let's get started, but before that please do like my video, share my video and please subscribe to my channel below. So today we're gonna start with the FIR, that is the first information report. Now first information report generally covers under section 154 of CrPC. In this, the police gets the statutory power to lodge FIR. There is no need to get the permission from the court in order to arrest that person if the person has done the cognizable offences. Then we have section 154 of CrPC. Before that, there are certain ingredients that needs to be there while considering it a FIR. Firstly, uh, it should be must relate to the cognizable offences, and information first in the point of time should be there, and the investigation of offence commences on the basis of the given information. So here the informant, what now FIR consists of, generally FIR means when the informant goes to the police station and he wants to file a complaint, file an FIR in front of the police officer against a person, that is called the FIR has been lodged. The information must be in a writing, must be in a written form, and the information or the book in which that information is being recorded is known as the books of records. Informant must receive a free copy of the information that was recorded. So the informant who went to the police station and he wanted to file the FIR, the person will get the information and get the free copy of the information from the police authorities. Then now, first of all, when I'm talking about the arrest of a police of woman, sorry, when we are talking about the arrest of a woman, so generally we all know that when the arrest is done of a woman, or when the woman is arrested, it is done by the woman officer herself. So a woman police officer or any woman officer must record the statement made by a woman where it relates to any offense. Generally we know there are certain offenses related to the woman, or certain offenses that woman faces, like your harassment is there, stalking is there, there 354 to 354A, 354D, 376A to 376D, dowry, death, cruelty. So there are the laws which are made to protect the interest of the woman and to make them secure. So here the police officer, generally a police officer will lodge a complaint which the woman is giving. Okay. Then we have what is cognizable offences. As I told you, FIR generally consists of the, or FIR must relate to the cognizable offences. So what is generally a cognizable offence is? So section 2 of the Code of Criminal Procedure defines a cognizable offence. A cognizable offence is one in which a police officer can make an arrest without the need of the warrant. Generally we will study later on about the arrest part. Here the arrest has two things: arrest with warrant and arrest without warrant. When we know the offenses of such a dangerous nature, or when the we know that the offense is such kind of when we know that the offense is such a nature that the evidence may get hindered, the evidence may get disturbed or changed somehow, then the police can arrest a person without warrant. Or when the offense is such a nature which is highly dangerous for the people, then it will be a cognizable offenses, and in that case the police will arrest the person without warrant. Then we have procedure for filing an FIR under section 154 of CrPC. Now there is a full-fledged procedure of filing the FIR. Firstly, an officer in charge of a police station with jurisdiction over the case must receive the information to investigate. For example, I am the officer of Punjab, an officer in charge of a police station. I am the officer in charge of a particular police station under whose jurisdiction the case has been investigated or the offense has been committed. It is my duty, being the officer, to know about that case, to know about that offense, and to start the investigation as soon as possible. Then, if the information is provided to the officer verbally, it must be converted to the writing. Generally, it is not always possible to be, file a complaint in writing. Sometimes people do the telephonic FIR also. That is also valid. Then, when the police officer get a phone call and a person wants to, or informant wants to lodge FIR telephonically, then it is the duty of the police officer to write that complaint, telephonic complaint, in their books of record in order to make that in writing. If the information is provided in writing or is reduced to writing as described above, the informant must sign it. Informant must verify the information that has been recorded in the writing. So first of all, in order to make that conversation, in order to make that information in FIR, we need to make that in a writing. That should be in a written form, that should be signed by the presiding officer or a police officer who is in the charge of that particular police station in a within the local territory. All these things needed to be taken into consideration, and the information as it was documented in the aforementioned way will then be immediately delivered to the informant in a copy. Now, whatever there was a conversation between the informant and the police officer, both will get the copy of the conversation, both will get the documents delivered to each other. Then, what are the contents of the FIR? FIR serves as the very foundation for the investigation and provides a means of ensuring swift and the proper justice. Therefore, it is crucial that following elements be covered in the FIR. Now, generally, we all know in FIR what we need to be there. What we need to consider over there is the complainant's name and the address, information on the incident date, time, and place. Incident actual fact as they happened, not the one which you are pretending it to be. The identities and the descriptions of those engaged and the details of the witness. Generally, when the offense has been committed in any area, we know that witnesses will be there. There will be a presence of witnesses, so witnesses should also be there. Now, there is one more thing very considerable here. There is one more thing considerable here, that okay, for example, a police officer, while investigating in a particular area, in a normal sense, when the police officer asks a person to give his name, to mention his name and the address where he resides, and the other person denies of giving that thing, then it is the right of the police officer to arrest that person and to lock that person in the behind the bars. Then we have another thing here, an FIR filed by the accused. The individual who first filed the FIR alleging a murder later turned out to be the accused, then his report will not be the FIR report, as it was confessional and is an admission from him of a particular facts that are relevant to the topic at hand. For example, an accused, he came to police station and he filed an FIR. Though he was the accused, then whatever the FIR he filed will be quashed, will be void, and will be of no use, because he is the actual accused. He concealed some of the facts. He concealed some of the information that was relevant while doing investigation. So, like how, by whom the murder was committed as found by court, if accuser's admission in the court contests the accuracy of a particular claim, made regardless of whether the FIR is valid or not. So FIR will not be valid, because accused himself is the accused. He is guilty of a particular offense. Now, though he is concealing some facts and all, so that will FIR will not be a valid one. Where to file an FIR? It's a very, very, very leading thing which needed to be considered. FIR is to be filed at the police station nearest to the scene of the offense. It is the general meaning of it. An FIR cannot be denied by a police station if you go other than the territory where the offense happened. One should be aware that each police station has a jurisdictional area that includes the area where they are allowed to look into the offense. So, there was a case, generally we all know that FIR lodged in that police station where they have jurisdiction, okay, under which the crime was committed or took place. But there was a case of State of Andhra Pradesh versus Punati Ramube 1993 Supreme Court. Here, a person went to the police station to file the FIR which was out of the territorial jurisdiction where the offence had been committed. Police constable refused in filing or recording the complaint and it was out of the jurisdiction. But what Supreme Court said that person can lodge the FIR anywhere they want, irrespective where the jurisdiction resides. So here we are there is sometimes a topic of the territorial jurisdiction, but there are various circumstances where the person cannot file. Maybe he's living very far from that area where he's doing a telephonic FIR whatsoever. The person will or the person can file FIR in any police station even though when it is not within the territorial jurisdiction of the particular police station. Now, delay in lodging the FIR. Generally, we all know that when FIR is being delayed or when we know that when the offense has been committed, then we have to lodge the FIR as soon as possible. But what are the effects of delaying the FIR? Generally, when the FIR is being delayed, then it loses its authenticity. The authenticity that FIR contains will get quashed, will get eliminated. There was a case of Amar Singh versus Balwinder Singh 2003 Supreme Court. There is no need set deadline for submitting a police report. A simple delay in filing an FIR cannot serve as defense alone for destroying the creditability of the whole prosecution case. The court must examine the delay. Now, there may be some reasons why there was a delay in lodging the FIR, but the reason for delay in lodging the FIR should be true, should be accurate, should be relevant. It should not be self-made things. Then we have another thing here, evidentiary value of an FIR. Firstly, FIR is not considered as an evidence at all. It is not considered FIR, it's not considered as an evidence, but can only be used to corroborate the statement of the maker to proceed with the further. We can use FIR with the we can use the FIR to proceed with the investigation, but not to present that in front of the magistrate to act as an evidence. No. Under Section 157 of Indian Evidence Act 1872, it may be used to support an informant witness, but it can't be used to refute or undermine the testimony of the other witness. According to Section 155, Subclause 3 of Indian Evidence Act 1872, defense may utilize the FIR to challenge the creditability of the complainant, to use it as a proof of the informant actions in accordance with Section 8. So, here we are now. I got so many questions from children that do telephonic message consist of means FIR? Yes, FIR will be called. Whatever the telephonic conversation is going between the your informant and the police officer, that will be recorded as the FIR. There was a case in it, Sunil Kumar versus State of Madhya Pradesh. Then we have the importance of the FIR. Generally, it is the piece of evidence for the purpose of corroborating the oral evidence for further investigation, but not for anything else. Then, it's just for corroborating, contradicting, and discrediting to move with the further investigation. So, in this, generally we talked about the FIR, evidentiary value of FIR, territorial jurisdiction. Now, I think this is the end of the video. In this video, I just talk about some few things related to FIR. In the another video, or in the next video, I will cover up with the remaining contents of the FIR. So, thank you so much for watching me, for listening to me, and please do like my video, subscribe to my channel below and share with your friends. Thank you so much. And if you want to know something, please do comment in the comment section so I could give you I could solve your problems related to anything you want to know about from me. Thank you so much and have a good day.